Many thanks for staying with us. Every year, thousands of Kenyan children become victims of sexual abuse. But for many survivors, the trauma does not end after the assault. A new study has revealed that delays in the justice system, weak investigations, and limited support services are denying many children the protection and justice they desperately need. The assessment, conducted across 7 counties, paints a troubling picture of a system struggling to respond to one of the country's most serious child protection challenges. Grace Nganga reports.
For thousands of survivors of child sexual abuse in Kenya, the trauma does not end when the abuse stops. Instead, many find themselves navigating a justice system marked by delays, weak investigations, and inadequate support devices. A recent assessment by Midrit Huinate, examining child protection services through survivor journeys and case management processes, reveals significant gaps in how child sexual abuse cases are handled. The study, conducted in Nairobi, Mombasa, Kisumu, Busia, Nakuru, Kisii, and Garissa, found that children aged between 6 and 11 years account for the majority of survivors, with girls highly affected.
Gaps in coordination, survivor support, and policy implementation continue to hinder effective response to child sexual exploitation and abuse.
Most perpetrators are neighbors aged between 18 and 35 years, while defilement and sodomy remain the most commonly reported offenses. While reporting abuse is often seen as a first step towards justice, the findings suggest the journey that follows is often long and difficult. Only 33.3% of cases reviewed were concluded within 6 months. Nearly half took more than a year, with some lasting more than 2 years. In counties such as Garissa, Busia, and Kisii, cases frequently stretch between 2 and 3 years. For survivors, such delays can mean repeated court appearances, prolonged trauma, and in some cases, families abandoning the pursuit of justice altogether.
Because maybe of the penalties in the Sexual Offences Act, people are very willing to actually divert these cases and have them settled in the kangaroo courts.
The report also highlighted systemic weaknesses, including poor evidence preservation, limited trauma-informed support services, and weak coordination among agencies responsible for child protection. Although 42.1% of cases resulted in conviction and imprisonment, a considerable number ended without accountability. 14% resulted in acquittals, 7% were withdrawn, and 7 perpetrators absconded before cases could be concluded. Researchers warn that without stronger child protection systems, legal safeguards alone will not guarantee justice for survivors.
The study calls for stronger integration of data, systems, improved interagency coordination and collaboration.
The report further calls for stricter enforcement of child sexual exploitation and abuse laws and greater investment in survivor-centered services. Grace Nganga, KTN.